Rule 1.2 Duty of the parties. Rule 1.3. The overriding objective. 1.1. The overriding objective of these rules is to enable the court to deal with cases justly. 2. Dealing justly with the case includes a. Ensuring, so far as is practicable, that the parties are on an equal footing, b. Saving expense, c. Dealing with cases in ways which are proportionate to I. The amount of money involved, 2. The importance of the case, 3. The complexity of the issues, and 4. The financial position of each party. D. Ensuring that it is dealt with expeditiously, and e. Allotting to it an appropriate share of the court's resources, while taking into account the need to allot resources to other cases. Application by the court of the overriding objective. 1.2 The court must seek to give effect to the overriding objective when it 1. Exercises any discretion given to it by the rules, or 2. Interprets the meaning of any rule. Duty of the parties. 1.3 The parties are required to help the court to further the overriding objective. Part 1 The overriding objective. 2016 Supreme Court of Judicature of Trinidad and Tobago. 2 Consolidated Civil Proceedings Rules 2016. Cases. 2016 Privy Council. Consolidated Civil Proceedings Rules 2016-11. Part 2 Application and Interpretation of the Rules. Contents of this part. Citation and Commencement. Rule 2.1 Application of the Rules. Rule 2.2 Definitions. Rule 2.3 Who may exercise powers of the court. Rule 2.4 Powers, authority, and jurisdiction of the registrar. Rule 2.4a Powers, authority and jurisdiction of the masters. Rule 2.4b Court staff. Rule 2.5 Court's discretion as to where it deals with cases. Rule 2.6 Time, court to state calendar date. Rule 2.7 Time, computation. Rule 2.8 Time, vacations. Rule 2.9 Meaning of month. Rule 2.10 Documents. Rule 2.11 Time, alternative dispute resolution. Rule 2.12 Citation and Commencement. 2.1.1 These rules may be cited as the Civil Proceedings Rules 1998. 2. These rules came into effect on the 16th day of September 2005, subject to Part 80. 3. A reference to a rule as CPR XX or Rule XX is a reference to a rule so numbered in these rules. Application of the Rules. 2.2.1 Subject to Paragraph 3. These rules apply to all civil proceedings in the Supreme Court. 2. Civil proceedings includes judicial review and applications to the court under Section 14(1) of the Constitution under Part 56. 3. These rules do not apply to proceedings of the following kinds: LN 126 of 2011, LN 301 of 2012. 2016 Supreme Court of Judicature of Trinidad and Tobago. 12 Consolidated Civil Proceedings Rules 2016. A. Insolvency, including winding up of companies. B. Non-contentious probate proceedings. C. Family proceedings, except as provided in the Family Proceedings Rules. And D. Proceedings when the High Court is acting as a prize court. 4. In these rules, the word must wherever this word occurs shall be deemed to have been substituted by the word shall. Definitions. 2.3 In these rules, ADR procedures mean any procedures for alternative dispute resolution including, in particular, mediation, application and applicant have the meanings given by Rule 11.2. Body corporate includes a company or other body corporate wherever or however incorporated other than a corporation sole and includes a limited company unless a rule otherwise provides. Certificate of value has the meaning given by Rule 8.7. Chief Justice includes, in relation to any period in which the office of Chief Justice is vacant, the person for the time being performing the functions of the Chief Justice. Claim is to be construed in accordance with Part 8. Claim for personal injuries means proceedings in which there is a claim for damages in respect of personal injuries to the claimant or any other person or in respect of a person's death, and personal injuries includes any disease and any impairment of a person's physical or mental condition. Claimant means a person who makes a claim, and, in relation to any proceedings commenced before these rules came into force, includes a plaintiff in an action or the petitioner or applicant in any proceedings commenced by petition, originating summons or motion. Claim for a specified sum of money means a claim for a sum of money recoverable under a contract which is ascertained or capable of being ascertained as a matter of arithmetic, and b. for the purposes of Parts 12. Default judgment, and 14. Admissions, a claim for I. the cost of repairs executed to a vehicle or any property in, on, or abutting a road, or 2. any other actual financial loss, claimed as a result of damage which it is alleged to have been caused in an accident as a result of the defendant's negligence. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-13. Provided that the amount of each item in the claim is specified, and copies of receipted bills for the amounts claimed are attached to the claim form or statement of case. The Constitution means the Constitution of Trinidad and Tobago. Court means the High Court and where the context admits, and in Part 64, the Court of Appeal. Court office indicates a. the place where documents are to be filed, etc., and includes a registry or sub-registry, and b. where work of a formal or administrative nature under Rule 2.5.1 is to be dealt with by members of the court staff. Defendant means a person against whom a claim is made and, in relation to proceedings commenced before these rules came into force, includes a respondent to any originating summons or motion. External company means any incorporated body of persons that is formed under the laws of a country other than Trinidad and Tobago. Filing, in relation to a document, means delivering, sending it by facsimile. Transmission or posting it to the appropriate court office and is not completed until the document is received at that office. Fixed date claim is a claim form in Form 2 upon which there has been stated a date, time, and place for a first hearing of the claim. Limited company or company means a body corporate that is incorporated or continued under the Companies Act, Chap. 81:01, Master, subject to any direction under Rule 2.4.2, includes assistant master. Minor means a person under 18 years. Next friend has the meaning given by Part 23. Order includes a judgment, decree, rule, direction, award, or declaration. Overriding objective means the objective set out in Rule 1.1. Party includes both the party to the claim and any attorney at law on record for that party unless any rule specifies or it is clear from the context that it relates to the lay client or to the attorney at law. Patient means a person who by reason of mental disorder within the meaning of the Mental Health Act, Chap. 28:02, is incapable of managing his own affairs. Period for filing a defense has the meaning given by Rule 10.3. Proper officer means the registrar of the Supreme Court or any other person who from time to time may be designated as having, subject to the Chief Justice, managerial control of the Supreme Court and has custody of the seal of the Supreme Court and responsibility for funds in court. 2016 Supreme Court of Judicature of Trinidad and Tobago. 14 Consolidated Civil Proceedings Rules, 2016. Registrar means the registrar of the Supreme Court, the deputy registrar and assistant registrars. Statement of case includes a claim, defense, counterclaim, ancillary claim form, defense to counterclaim and a reply to a defense. Statutory rate of interest means the rate of interest on judgments prescribed for the time under Section 13 of the Remedies of Creditors Act, Chap. 809. Summary judgment is to be construed in accordance with Part 15. Who may exercise the powers of the court. 2.4. 1. Except where any enactment, rule or practice direction provides otherwise, the functions of the High Court may be exercised by any judge, master or registrar of that court, and the functions of the Court of Appeal may be carried out by any three or, in the case of procedural appeals, any two judges of the Court of Appeal. 2. The Chief Justice may by direction allocate the work of the court among judges, masters, and the registrar. Powers, authority, and jurisdiction of the registrar. 2.4a. 1. The registrar shall have power to transact all such business and exercise all such authority and jurisdiction as may be transacted and exercised by a judge sitting in chambers in respect of the following matters, that is to say, a. Assessments of costs referred to the registrar under Part 67.12, 2, b. Applications under Section 42 of the Petty Civil Courts Act, Chap. 421, c. The taking of an account when it has been ordered that the account be taken by the registrar, d. The hearing of judgment summonses under the Debtors Act, Chap. 807, and the rules made thereunder. E. Applications for the grant of probate or letters of administration or the resealing of a grant of probate or administration except where the proceedings are contentious. F. Applications for attachment of debt orders. G. Applications for the renewal of a writ of execution. H. Applications for permission to issue a writ of possession. I. Applications for permission to issue a writ of delivery of specified goods without the alternative of payment of the assessed value. J. Applications for relief under Section 18 of the Bills of Sale Act, Chap. 82:32. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-15. 2. It shall be lawful for the registrar stationed in Tobago, whenever there is no judge of the court present in Tobago, to make all such orders as may be necessary for the following purposes. A. For the protection, management, and custody of property, the subject matter of or in dispute in proceedings before the court. B. For granting of interim injunctions, including mandatory and freezing injunctions, search orders, or the appointing of a receiver when the court can exercise such jurisdiction by interim order. C. For giving interim authority to any executor or executrix or any receiver appointed by him to dispose of perishable articles, and to pay the money into court. Provided always that the registrar stationed in Tobago shall not be bound to make any order under the provisions of this rule, unless the urgency of the case and the interest of justice shall appear so to require, and provided also that he shall have power to alter, vary, or discharge any such order or orders. Powers, authority, and jurisdiction of the masters. 2.4b. 1. Subject to the provisions of this rule, a master shall have power to transact all such business and exercise all such authority and jurisdiction as may be transacted or exercised by a judge in chambers except in respect of the following matters and proceedings, that is to say, a. Matters relating to criminal proceedings or to the liberty of the subject. b. Proceedings for the grant of an injunction or other order under Section 23(5) of the Supreme Court of Judicature Act, Chap. 401, hereinafter in this rule referred to as the Act. C. Applications for judicial review or an application for a writ of habeas corpus. D. Application for an order of committal in proceedings to which Part 53 applies. E. Appeals from registrars. F. Applications under Section 34 of the Act for leave to institute legal proceedings. G. Proceedings in respect of which jurisdiction is given by any enactment specifically to a judge in chambers and in which the decision of the judge is final. H. Such business, authority, and jurisdiction as the Chief Justice may from time to time direct to be transacted or exercised by a judge in person. I. Any other matter or proceeding which by any of these rules is required to be heard only by a judge. 2016 Supreme Court of Judicature of Trinidad and Tobago. 16 Consolidated Civil Proceedings Rules 2016. 2. master shall have power to grant an injunction a. in the terms agreed by the parties to the proceedings in which the injunction is sought, or b. which is ancillary or incidental to a charging order under Part 49. 3. A master shall have power to make a stop order under Part 50. 4. A master shall have the power to make an order under Part 52 for the appointment of a receiver to obtain payment of the judgment debt from the income or capital assets of the judgment debtor and to grant an injunction if, and only so far as the injunction is ancillary or incidental to such an order. 5. Notwithstanding paragraph 1, it shall be lawful for a master in Tobago to make all such orders as can be made by the registrar under Rule 2.4a.2. 6. A master may refer to a judge any matter which he thinks should be properly decided by a judge, and the judge may either dispose of the matter or refer it back to the master with such directions as he thinks fit. Court Staff 2.5. 1. Where these rules refer to an act being done by the court office or require or permit the performance of an act of a formal or administrative character, that act may be performed by a member of the court staff authorized in writing by the Chief Justice. 2. Where these rules expressly so provide, any other functions of the court may be carried out by a member of the court staff authorized in writing by the Chief Justice. Court's discretion as to where it deals with cases 2.6. 1. The court may deal with a case at any place that it considers appropriate. 2. In considering what place may be appropriate, the court must consider the convenience of such place to the parties and their attorneys at law. Time. The court to state calendar date 2.7 when making any judgment, order, or direction which imposes a time limit for doing any act. The court must, wherever practicable, a. state the calendar date, and b. include the time of day by which such act must be done. Time. Computation 2.8. 1. This rule shows how to calculate any period of time for doing any act which is fixed. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-17. A. By these rules, b. by any practice direction, or c. by any order of the court. 2. All periods of time expressed as a number of days are to be computed as clear days. 3. In this rule, clear days means that in computing the number of days, the day on which the period begins and the day on which the period ends are not included. Examples: a. Notice of an application must be served at least 3 days before the hearing. If application is to be heard on Friday, October 20th, the last date for service is Monday, October 16th. b. A trial bundle must be filed not more than 7 days before the date on which the trial is due to start. If the trial is due to start on Tuesday, October 17th, the bundle must be filed on or after Monday, 9th October. 4. Where the specified period a. is 5 days or less, and b. includes a Saturday or Sunday, or 2. any other day on which the court office is closed, that day does not count. 5. When the period fixed. A. By these rules. B. By any practice direction, or c. by any order, for doing any act at the court office ends on a day on which the court is closed, it shall be in time if done before 4 p.m. on the next day on which the court is open. 6. When the period fixed, a. by these rules, b. any practice direction, or c. by any order, for doing any act which does not need to be done at court ends, I. on a Saturday or Sunday, 2. on any public holiday, or 3. on Carnival Monday or Carnival Tuesday, it must be done before 4 p.m. on the next ordinary business day. 2016 Supreme Court of Judicature of Trinidad and Tobago. 18 Consolidated Civil Proceedings Rules 2016. Time, Vacations 2.9. 1. During the long vacation time prescribed by these rules for serving any statement of case other than the claimant's statement of case served with his claim form does not run. 2. However, this rule does not override any order of the court which specifies a date for service of a statement of case. Meaning of month 2.10. Where month occurs in any order or any other document, it means a calendar month. Documents 2.11a. So far as is practicable, every document prepared for use in the Supreme Court must be on letter-size paper, approximately 11 inches long by 8.5 inches wide. Margins of 1 inch, 25 millimeters, must be left at top and bottom and of 1.5, 38 millimeters, at each side. B. Every document to be filed at the court must be headed with the title of the proceedings and I. A description of the document. 2. A statement of the nature of the case. 3. Be endorsed with the name, firm name, bar number, address, telephone and fax numbers, if any, and email address, if any, of the attorney-at-law filing the document, and where an advocate attorney has been instructed, the name, bar number, telephone and fax numbers, if any, and email address, if any, of that advocate. Advocate. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-19. Time, Alternative Dispute Resolution 2.12 during the period specified by the court or these rules for the conduct of any alternative dispute resolution procedure approved by the court. Time prescribed by these rules for filing any document or doing any other thing does not run. Rule 25.1 (c) makes provision in relation to dispute resolution. Rule 26.1 provides for the court's general powers of case management. Former Rule 1. The current Rule 2.2 was brought about by the revocation and substitution of Sub-Rule 3 by Rule 3 of the Civil Proceedings Amendment Rules, 2012 Legal Notice Number 301 of 2012. This subrule was previously deleted and substituted by Rule 3 of the Civil Proceedings Amendment Rules, 2011 Legal Notice Number 126 of 2011. As set out in the 2011 amendment, Subrule 3 read as follows. 3. These rules do not apply to proceedings of the following kinds. A. Insolvency, including winding up of companies. B. Non-contentious probate proceedings. C. Family proceedings except as provided in the Family Proceedings Rules. And D. Proceedings when the High Court is acting as a prize court. As set out in the 2006 publication, Subrule 3 read as follows. 3. These rules do not apply to proceedings of the following kinds. Insolvency, including winding up of companies. Non-contentious probate proceedings. Proceedings under the Matrimonial Causes Rules and the Family Proceedings Rules. Proceedings when the High Court is acting as a prize court. 2. Rule 2.12 was inserted by Rule 4 of the Civil Proceedings Amendment Rules, 2012 Legal Notice Number 301 of 2012. LN 301 of 2012. 2016 Supreme Court of Judicature of Trinidad and Tobago. 20 Consolidated Civil Proceedings Rules 2016. Cases. 2016 Privy Council/Court of Appeal. In re-an application by Liberty Development Company Limited, in liquidation, Civ App No P091 of 2015, March 24, 2016, appeal allowed Rule 2.2, 3, application of CPR, winding up petition. Germain Raymer v. Lex Caribbean Civ App No P258 of 2016, November 21, 2016, appeal dismissed CV 2015-01621, March 23, 2016, Rule 2.3, Definition of Statement of Case, Reply, also under Part 26. 2014 High Court. Ricardo Welch v. the Attorney General of Trinidad and Tobago and others CV 2013-04279, March 19, 2014, Rule 2.9, Litigant in Person, Interpretation of Rule, Time, Violation of Constitutional Right, also under Parts 11 and 67. 2008 High Court. Ropnarine Persad and another v. Danny Bakasoon and another CV 2006-00868, May 20, 2008, Rule 2.8 Time, Extension of Time, Amended Statement of Case, Filing without permission, also under Part 24. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-21. Part 3 Forms. Contents of this part forms Rule 3.1. Forms 3.1 1. The forms in the appendices to these rules and, where appropriate, practice forms must be used in the cases to which they apply. 2. A form may be varied if the variation is required by the circumstances of a particular case. 3. However, a form must not be varied so as to leave out any information or guidance which the form in the appendix or practice direction gives to the intended recipient of the form. 4. Where these rules require a party to send a blank form to any other party, he must send it without variation except the insertion of the title of the case and the court address to which that document is to be returned. 5. A form marked with the word seal must bear the seal of the Supreme Court. 2016 Supreme Court of Judicature of Trinidad and Tobago. 22 Consolidated Civil Proceedings Rules 2016. Cases. Consolidated Civil Proceedings Rules 2016-23. Part 4 Practice Directions and Guides. Contents of this part: who may issue practice directions. Rule 4.1 Scope of practice directions. Rule 4.2 Publication of practice directions. Rule 4.3 Date from which practice directions take effect. Rule 4.4 Compliance with practice directions. Rule 4.5 Practice Guides. Rule 4.6 Who may issue practice directions. 4.1 Practice directions may only be issued by the Chief Justice. Scope of practice directions. 4.2 1. A practice direction may be issued in any case where provision for such a direction is made by these rules. 2. Where there is no express provision in these rules for such a direction, the Chief Justice may give directions as to the practice and procedure to be followed in the conduct of litigation and in the Supreme Court generally. For the avoidance of doubt, the words "the conduct of litigation" refers to conduct before as well as after the commencement of a claim. Publication of practice directions. 4.3 Practice directions must be a. Published in the Trinidad and Tobago Gazette, and b. Displayed and made available at each court office. Date from which practice directions take effect. 4.4 A practice direction takes effect from the date of publication in the Trinidad and Tobago Gazette unless the direction specifies some other date. Compliance with practice directions. 4.5 1. A party must comply with any relevant practice directions unless there are good reasons for not doing so. 2016 Supreme Court of Judicature of Trinidad and Tobago. 24 Consolidated Civil Proceedings Rules 2016. 2. If a party fails to comply with a practice direction, the court may make an order against him under Part 26, Powers of the Court, or Part 66, Costs General. Practice Guides. 4.6 1. The Chief Justice may issue practice guides to assist parties in the conduct of litigation, and for the avoidance of doubt, the words "the conduct of litigation" refer to conduct before as well as after the commencement of a claim. 2. Parties must have regard to any relevant practice guide. 3. The court may take into account the failure of any party to comply with any practice guide when deciding whether or not to make an order under Part 26, Powers of the Court, or Part 66, Costs General. Cases. 2015 High Court. Warren Elias v. Dionarine Mahaber CV 2013-05192, January 28, 2015, Rule 4.5, Service, PRE Action Protocol Letter, PRE Action Protocols, Practice Direction, also under Part 68. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-25. Part 5 Service of Claim Form. Contents of this part: Service of Claim Form. Normal Method Rule 5.1 Statement of Case to be served with Claim Form Rule 5.2 Method of Personal Service Rule 5.3 Permitted Place of Service Rule 5.4 Proof of Personal Service Rule 5.5 Service on a Limited Company Rule 5.6 Service of Claim Form on a Firm or Partnership Rule 5.7 Service of Claim Form on a Body Corporate Rule 5.8 Proof of Postal Service Rule 5.9 Alternative Methods of Service Rule 5.10 Service of Claim Form on Minors and Patients Rule 5.11 Power of Court to make an order for service by a specified method Rule 5.12 Proof of Service by specified method Rule 5.13 Service of Claim Form by contractually agreed method Rule 5.14 Service of Claim Form on Agent of Principal who is overseas Rule 5.15 Service of Claim Form for possession where land vacant Rule 5.16 Deemed Date of Service Rule 5.17 Service of Claim Form, Normal Method 5.1 The general rule is that a claim form must be served personally. Part 6 deals with service of other documents. Statement of Case to be served with Claim Form 5.2. 1. The general rule is that the claimant's statement of case must be served with the claim form. 2. However, the claim form may be served without the statement of case with the permission of the court. Rule 8.2 deals with the power of the court to permit issue and service of a claim form without a statement of case. 2016 Supreme Court of Judicature of Trinidad and Tobago. 26 Consolidated Civil Proceedings Rules 2016. Method of Personal Service. 5.3 A. A document is served personally on an individual by handing it to or leaving it with the person to be served. B. A document is served personally on a company or other corporation by handing it to and leaving it with a director, officer, receiver, receiver-manager or liquidator of the company or other corporation. Permitted place of service. 5.4 Except as permitted by Part 7, Service out of the jurisdiction, a document must be served at a place within the jurisdiction. Proof of personal service. 5.5. 1. Personal service of any document is to be proved by an affidavit sworn by the server of the document stating a. The date and time of service, b. The precise place or address at which it was served, c. Precisely how the person served was identified, and d. Precisely how service was effected. 2. Where the person served was identified by another person, there must also be filed where practicable an affidavit by that person proving the identification of the person served and stating how that person was able to identify the person served. 3. Where the server identified the person to be served by means of a photograph or description, there must also be filed an affidavit by a person verifying the description or photograph as being of the person intended to be served and stating how that person was able to verify the description or photograph as being of the person intended to be served. Service on a limited company. 5.6 Service on a limited company may be effected a. By sending the claim form and statement of case or other document by telefax or prepaid post addressed to the registered office of the company, b. By leaving the claim form and statement of case or other document at the registered office of the company, c. By serving personally the claim form and statement of case or other document on any director, officer, receiver, receiver-manager, or liquidator of the company. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-27. D. By serving personally the claim form and statement of case or other document on any manager or other senior employee at any place of business of the company having a real connection with the claim, or e. in any other way allowed by an enactment. Service of claim form on a firm or partnership. 5.7. 1. Service on a firm or partnership may be effected a. By serving personally the claim form and statement of case on any partner of the firm, or b. By serving personally the claim form and statement of case on any responsible person at any place of business of the firm or partnership having a real connection with the claim. 2. Where the claimant knows that a partnership has been dissolved when the claim is issued, the claim form and statement of case must be served on every person within the jurisdiction whom the claimant seeks to make liable. Service of claim form on a body corporate. 5.8 Service on a body corporate, other than a limited company, may be effected a. by sending the claim form and statement of case or other document to be served by registered post to the principal office of the body corporate, b. by serving the claim form and statement of case or other document personally on any principal officer of the body corporate, or c. in any other way allowed by any enactment. Principal officer means the mayor, chairman or president of the body, or the town clerk, chief executive officer, clerk, secretary, treasurer or other similar officer of the body. Rule 58.3 deals with service on the state. Proof of postal service. 5.9 1. Service by post must be proved by an affidavit of service by the person responsible for posting the claim form and statement of case or other document to the person to be served. 2. The affidavit must state a. the date and time of posting, and b. the address to which it was sent. 2016 Supreme Court of Judicature of Trinidad and Tobago. 28 Consolidated Civil Proceedings Rules 2016. Alternative methods of service. 5.10 1. Instead of personal service, a party may choose an alternative method of service. 2. Where a party chooses an alternative method of service and the court is asked to take any step on the basis that the claim form and statement of case have been served, the party who served the claim form and statement of case must prove service to the satisfaction of the court by filing an affidavit. A. Giving details of the method of service used, and b. Showing that I. the person intended to be served was able to ascertain the contents of the documents, or 2. It is likely that he would have been able to do so, and c. Stating the time when the person served was or was likely to be in a position to ascertain the contents of the documents. 3. The court office must immediately refer any affidavit filed under paragraph 2 to a master or judge who must consider the evidence and endorse on the affidavit whether it satisfactorily proves service. 4. If the court is not satisfied with the method of service, the court office must fix a date, time, and place to consider making an order under Rule 5.12 and give at least 3 days' notice to the claimant. Service of claim form on minors and patients. 5.11 1. Paragraphs 2 to 5 specify the persons on whom a claim form and statement of case must be served if it would otherwise be served on a minor or patient. 2. A claim form and statement of case which would otherwise be served on a minor who is not also a patient must be served on one of the minor's parents or guardians or, if there is no parent or guardian, on the person with whom the minor resides or in whose care the minor is. 3. If a person is authorized under Part 7 of the Mental Health Act, Chap. 28:02, to conduct the proceedings in the name of the patient or on his behalf, a claim form and statement of case must be served on that person. 4. If there is no person so authorized, a claim form and statement of case must be served on the person with whom the patient resides or in whose care the patient is. 5. The court may order that, although paragraphs 2 to 4 have not been complied with, the claim form and statement of case are to be treated as if they have been properly served. 6. The court may make an order permitting the claim form and statement of case to be served on the minor or patient, or on some other person other than the person specified in paragraphs 2 to 4. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-29. 7. An application for an order under paragraph 5 or 6 may be made without notice. Part 23 deals generally with parties who are minors or patients. Power of court to make an order for service by a specified method. 5.12 1. The court may direct that a claim form and statement of case may be served by a method specified in the court's order. 2. An application for an order to serve by a specified method may be made without notice but must be supported by evidence, a. specifying the method of service proposed, and b. showing that that method of service is likely to enable the person to be served to ascertain the contents of the claim form and statement of case. Proof of service by specified method 5.13 Service must be proved by an affidavit by the person who served the document in accordance with the court's order showing that the terms of the order had been carried out. Service of claim form by contractually agreed method 5.14 1. A claim form and statement of case containing a claim in respect of a contract may be served by any method permitted by the contract. 2. Where the claim form and statement of case are served within the jurisdiction in accordance with the contract, they are to be treated as having been served on the defendant. 3. Where the claim form and statement of case are served out of the jurisdiction in accordance with the contract, they are not to be treated as having been served on the defendant unless service out of the jurisdiction is permitted by Part 7. Service of claim form on agent of principal who is overseas 5.15 1. Where the conditions specified in paragraph 2 are satisfied, the court may permit a claim form and statement of case relating to a contract to be served on a defendant's agent. 2. The court may not make an order under this rule unless it is satisfied that a. The defendant cannot be served within the jurisdiction, b. The contract to which the claim relates was entered into within the jurisdiction with or through the defendant's agent, and c. At the time of the application either the agent's authority had not been terminated or he is still in business relations with his principal. 2016 Supreme Court of Judicature of Trinidad and Tobago. 30 Consolidated Civil Proceedings Rules 2016. 3. An application may be made without notice but must be supported by evidence. 4. An order under this rule must state the periods within which the defendant must a. Enter an appearance or make an admission under Rule 14.4, 14.5, 14.6 or 14.7, and b. File a defense. 5. When the court makes an order under this rule, the claimant must send to the defendant at his address out of the jurisdiction copies of a. The order, and b. The claim form, and c. The statement of case, and d. The document prescribed in Rule 8.15 1a-e. Service of claim form for possession of land where land vacant 5.16 1. Paragraph 2. Deals with the service of a claim form and statement of case for possession of land where there is no person in occupation of the land and service cannot otherwise be effected on the defendant. 2. The court may direct that a claim form and statement of case be served by affixing a copy of the claim form to some conspicuous part of the land and by publishing a notice of the claim once in a specified daily newspaper of general circulation. An application for an order under this rule, a. may be made without notice, but b. must be supported by evidence that there is no person in possession of the land and that there is no other method of serving the defendant. Deemed date of service 5.17 1. Where a claim form has been served by prepaid post, it is deemed to be served, unless the contrary is shown, on the 14th day after it was posted. 2. If a claim is sent to a party's attorney at law who certifies that he accepts service on behalf of his client, the claim is deemed to have been served on the date on which the attorney at law certifies that he accepts service. 3. Where an appearance is entered, whether or not the claim form has been duly served, the claimant may, if he so wishes, treat the date of entering the appearance as the date of service. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-31. Cases. 2016 Privy Council/Court of Appeal. Brent Nunes v. Her Worship Magistrate Marissa Gomez Civ App No. P. 123 of 2016, November 7, 2016. Appeal allowed CV 2015-02609, April 20, 2016. Rule 5.5 Affidavit of Service, Good and Proper Service, Rebuttable Presumption, also under Part 26. 2015 Privy Council/Court of Appeal. Ravindranath Maharaj v. Simon K. McCoon and others Civ App No. S. 119 of 2015, September 21, 2015. Appeal allowed CV 2013-3646, July 16, 2015. Service of claim, alternative mode of service. Davidson Ramsuk v. Carol N. Crossley and another Civ App No P016 of 2015, May 11, 2015, appeal dismissed CV 2010-03823, January 19, 2015, Rule 5.1, Rule 5.2, Rule 5.5, Claim Form, Personal Service, Identification Issue. High Court. Riyadh Marketing Limited v. Eckler Chemicals Limited CV 2015-00670, December 16, 2015, extension of time for service of claim form, purpose of interpretation of court order, also under Part 8. 2016 Supreme Court of Judicature of Trinidad and Tobago. 32 Consolidated Civil Proceedings Rules 2016. 2014 Privy Council/Court of Appeal. Deswortband v. Ruben Kanhai and another Civ App Nos. S285 and S286 of 2013, January 27, 2014, appeal allowed CV 2012-02682, CV 2012-02684, December 5, 2013, Rule 5.5, Proof of Service, Identification Issue, also under Part 13. High Court. Coleridge Camta v. Zahida Camperty CV 2014-00674, March 19, 2014, Rule 5.10, 3, Claim Form, Registered Mail, Improper Service. 2011 Privy Council/Court of Appeal. Sarah Young and others v. Lena Pegouz and another Civ App No. P271 of 2010, February 14, 2011, appeal dismissed CV 2008-00876, December 17, 2010, Rule 5.10, Good and Proper Service, Insufficient Evidence, also under Parts 3 and 9. 2007 High Court. Gerard Mahadio v. Jessel R. Ramsander CV 2007-01218, November 30, 2007, Rule 5.10, Rule 5.12, Service of Claim Form, Reasonable Steps, Alternative Addresses, also under Part 8. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings, Rules 2016-33. Part 6 Service of Other Documents. Contents of this part. Who is to serve documents other than the claim form? Rule 6.1 Method of Service. Rule 6.2 Address for serving such documents. Rule 6.3 Address for serving documents where no address for service is given. Rule 6.4 Service of documents on a person not a party. Rule 6.5 Deemed date for service by post. Rule 6.6 Power of court to dispense with service. Rule 6.7 Service of notices, etc. on the Attorney General. Rule 6.8 Who is to serve documents other than the claim form? 6.1 Any order which requires service must be served by the court, unless a rule provides that a party must serve the document in question, or b. the court orders otherwise. 2. Any other document must be served by a party, unless a. these rules provide otherwise, or b. the court orders otherwise. Method of service. 6.2 Where these rules require a document other than a claim form to be served on any person, it may be served by any of the following methods: a. Personal service in accordance with Rule 5.3, b. Prepaid post, c. Delivery, or d. Facsimile transmission or other means of electronic communication if permitted by a relevant practice direction unless the court orders otherwise. 2016 Supreme Court of Judicature of Trinidad and Tobago. 34 Consolidated Civil Proceedings Rules 2016. Address for serving such documents. 6.3 If a party has given an address at which documents for him may be served, the documents must be delivered or posted to him at that address. 2. If the party has given a facsimile transmission number in his address for service, the documents may be sent by facsimile transmission to that number. Address for serving documents where no address for service is given. 6.4 Where no address is given for service, the document must be served by leaving it or posting it at or to a. the business address of any attorney who purports to act for him in the proceedings. B. In the case of an individual, his usual or last known place of residence. C. In the case of a proprietor of a business, either I. His usual or last known place of residence, or 2. His place of business or last known place of business, or D. In the case of a firm or partnership, either I. The principal or last known address of the firm or partnership, or any place where the firm or partnership carries on business and which has a real connection with the claim, or 2. The usual or last known place of residence of one of the partners. 2. The provisions of Part 5 may be applied to such a document as if it were a claim form. Service of documents on a person not a party. 6.5 If the court or a party is to serve documents on a person who is not a party, such documents must be served by one of the methods specified in Part 5. Deemed date of service by post. 6.6 Any document served by prepaid post under this part shall be deemed to be served on the 14th day after posting. Power of court to dispense with service. 6.7 1. The court may dispense with service of a document if it is appropriate to do so. 2. An application for an order to dispense with service may be made without notice. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-35. Service of notices, etc., on the Attorney General. 6.8 1. This rule applies where any document has to be served on the Attorney General in connection with any proceedings of which notice has to be given to the Attorney General and no express provision as to service is made by any enactment or rule. 2. Any such document must be served in accordance with Rule 58.3. Cases. 2015 High Court. Roger Franco v. Paul Priscilla and others. CV 2014-02934, September 15, 2015. Rule 6.6, Default Judgment, Order sent via post, deemed TOB served, also under Part 13. 2016 Supreme Court of Judicature of Trinidad and Tobago. 36 Consolidated Civil Proceedings Rules 2016. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-37. Part 7 Service of Court Process. Out of the jurisdiction. Contents of this part. Scope of this part. Rule 7.1 General Rule as to service out of jurisdiction. Rule 7.2 Service out of jurisdiction in specified proceedings. Rule 7.3 Proceedings, which include other types of claim. Rule 7.4 Application for permission to serve out of jurisdiction. Rule 7.5 Application to set aside service under Rule 7.3. Rule 7.6 Appearance, where claim form served out of jurisdiction. Rule 7.7 Mode of service. General provisions. Rule 7.8 Service through foreign governments, etc. Rule 7.9 Procedure where claim form is to be served through foreign governments, etc. Rule 7.10 Service of claim form on a state where court permits service out of jurisdiction. Rule 7.11 Translation of claim form. Rule 7.12 Undertaking to be responsible for expenses of minister with responsibility for foreign affairs. Rule 7.13 Service of court process other than claim form. Rule 7.14 Meaning of Hague Convention. Rule 7.15. Scope of this part. 7.1 This part contains provisions about a. The circumstances in which court process may be served out of the jurisdiction, and b. The procedure for serving court process out of the jurisdiction. General Rule as to service out of jurisdiction. 7.2 A claim form may be served out of the jurisdiction only if a. Rule 7.3 allows it to be served out of the jurisdiction, and b. The court gives permission. 2016 Supreme Court of Judicature of Trinidad and Tobago. 38 Consolidated Civil Proceedings Rules 2016. Service out of jurisdiction in specified proceedings. 7.3 1. A claim form may be served out of the jurisdiction if the proceedings are listed in this rule. Features which may arise in any type of claim. 2. A claim form may be served out of the jurisdiction where a. A claim is made for a remedy against a person domiciled or ordinarily resident within the jurisdiction. B. A claim is made for an injunction ordering the defendant to do or refrain from doing some act within the jurisdiction. Or C. A claim is made against someone on whom the claim form has been or will be served and I. There is between the claimant and that person a real issue which it is reasonable for the court to try, and 2. The claimant now wishes to serve the claim form on another person who is a necessary and proper party to that claim. Claims about contracts. 3. A claim form may be served out of the jurisdiction where a claim is made to enforce, rescind, dissolve or otherwise affect a contract or to obtain any other remedy in respect of a breach of contract and, in either case, the contract, I, was made within the jurisdiction, 2, was made by or through an agent trading or residing within the jurisdiction, 3, is by its terms or by implication governed by the law of Trinidad and Tobago, or 4. Contains a term to the effect that the court shall have jurisdiction to determine any claim in respect of the contract. B. A claim is made in respect of a breach of contract committed within the jurisdiction. Or C. A claim is made for a declaration that no contract exists. Claims in tort. 4. A claim form may be served out of the jurisdiction where a claim in tort is made and A. The damage was sustained within the jurisdiction. Or B. The damage sustained resulted from an act committed within the jurisdiction. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings, Rules 2016-39. Enforcement. 5. A claim form may be served out of the jurisdiction where a claim is made to enforce any judgment or arbitral award made within the jurisdiction. Claims about property within the jurisdiction. 6. A claim form may be served out of the jurisdiction where a. The whole subject matter of the proceedings is I. Land located within the jurisdiction, or 2. The perpetuation of testimony relating to land located within the jurisdiction. B. A claim is made in order to interpret, rectify, set aside or enforce a document, obligation or liability affecting land located within the jurisdiction. Or C. A claim is made I. For a debt secured on land. 2. To assert, declare, or determine rights in or over land. Or 3. To obtain authority to dispose of land. And, in any of these cases, the land is located within the jurisdiction. Claims about trusts, etc. 7. A claim form may be served out of the jurisdiction where a claim is made for any remedy which might be obtained in proceedings to execute the trusts of a written instrument where I. The trusts ought to be executed according to the law of Trinidad and Tobago, and 2. The person on whom the claim form is to be served is a trustee of the trusts. B. A claim is made for any remedy which might be obtained in proceedings for the administration of the estate of a person who died domiciled within the jurisdiction. Or C. A claim is made in probate proceedings as defined in Part 72. D. A claim is made for a remedy against the defendant as constructive trustee where the defendant's alleged liability arises out of acts committed within the jurisdiction. Admiralty proceedings. 8. This rule does not apply to an admiralty claim in rem. 2016 Supreme Court of Judicature of Trinidad and Tobago. 40 Consolidated Civil Proceedings, Rules 2016. Proceedings which include other types of claim 7.4 where the claimant makes a claim which falls within a. Rule 7.3, 3. Claims about contracts, b. Rule 7.3, 4. Claims in tort, or c. Rule 7.3, 7, d. Claims against the defendant as a constructive trustee. The court may grant any claim for a remedy which I. Does not fall within Rule 7.3, but 2. Arises out of the same facts or substantially the same facts as the claim in respect of which the order is made. Application for permission to serve out of jurisdiction 7.5 An application for permission to serve out of the jurisdiction may be made without notice but must be supported by evidence stating a. The grounds on which the application is made, b. That in the deponent's belief the claimant has a claim with a realistic prospect of success, and c. In what place, within what country, the defendant may probably be found. Application to set aside service under Rule 7.37.6. 1. Any person on whom a claim form has been served out of the jurisdiction under Rule 7.3 may apply to set aside service of the claim form. 2. The court may set aside service under this rule where a. Service out of the jurisdiction is not permitted by the rules, b. The case is not a proper one for the court's jurisdiction, or c. The claimant does not have a good cause of action. 3. This rule does not limit the court's power to make an order under Rule 9.7, Procedure for Disputing the Court's Jurisdiction. Appearance where claim form is served out of jurisdiction. 7.7 Where a claim form which is to be served out of the jurisdiction under Rule 7.3 requires the defendant to enter an appearance. The period within which it must be entered is to be determined by reference to any relevant practice direction. Mode of service, General Provisions 7.8, 1, subject to the following paragraphs of this rule, where a claim form is to be served out of the jurisdiction, it may be served, a. Personally by the claimant or his agent. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-41. b. In accordance with the law of the country in which it is to be served, or c. By a method provided for by I. Rule 7.9, Service through foreign governments, etc. 2. Rule 7.11, Service on a state. 2. Nothing in this part or in any court order or direction authorizes or requires any person to do anything in the country where the claim form is to be served which is against the law of that country. 3. Except where this part provides otherwise, the following rules, which apply where a claim form is to be served within the jurisdiction, also apply where a claim form is to be served out of the jurisdiction. A. Rule 8.1, 2. Date when claim form issued. B. Rule 8.2, Statement of case to be issued and served with claim form. C. Rule 8.15, Form of appearance and defense form to be sent with a claim. D. Rule 5.17, Deemed date of service, and E. Rule 5.12, Service by A. Specified method. Service through foreign governments, judicial and consular authorities. 7.9, 1. The methods of service permitted by this rule are in addition to any method of service permitted under A. Rule 7.8, 1a, or B, any relevant civil procedure convention. Service under the Hague Convention. 2. Where a claim form is to be served on a defendant in any country which is a party to the Hague Convention, the claim form may be served a. Through the authority designated under the Hague Convention in respect of that country, or b. If the law of that country permits, I. Through the judicial authorities of that country, or 2. Through the consular authority of Trinidad and Tobago in that country. Service under other conventions. 3. Where a claim form is to be served on a defendant in any country which is a party to a civil procedure convention to which Trinidad and Tobago is a party, other than the Hague Convention, providing for service in that country of court process, the claim form may be served if the law of that country permits, I. Through the judicial authorities of that country, or 2016 Supreme Court of Judicature of Trinidad and Tobago. 42 Consolidated Civil Proceedings Rules 2016. 2. Through the consular authority of Trinidad and Tobago in that country. Service where there is no applicable convention. 4. Where a claim form is to be served on a defendant in any country with respect to which there is no relevant civil procedure convention providing for service in that country of court process, the claim form may be served, if the law of that country so permits. I. Through the government of that country, where that government is willing to serve it, or 2. Through the consular authority of Trinidad and Tobago in that country. Procedure where claim form is to be served through foreign governments, judicial authorities, and consular authorities. 7.10, 1. This rule applies where the claimant wishes to serve the claim form. A. Through the judicial authorities of the country where the claim form is to be served. B. Through the consular authority of Trinidad and Tobago in that country. C. through the authority designated under the Hague Convention or any other relevant civil procedure convention in respect of that country, or d. through the government of that country. 2. Where this rule applies, the claimant must file a request for service of the claim by his chosen method, b. a copy of the claim form, c. an additional copy of the claim form for each person to be served, and d. any translation required by Rule 7.12. 3. When the claimant files the documents specified in paragraph 2, the court office must a. seal the copy of the claim form and b. send the documents filed to the permanent secretary to the Ministry with responsibility for foreign affairs with a request that he arrange for the claim form to be served by the method indicated in the request for service filed under paragraph 2, or, where that request indicates alternative methods, by the most convenient method. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-43. 4. An official certificate which a. states that the claim form has been served in accordance with this rule either personally, or in accordance with the law of the country in which service was effected, b. specifies the date on which the claim form was served, and c. is made by I, a consular authority of Trinidad and Tobago in the country where the claim form was served, 2. the government or judicial authorities in that country, or 3. any other authority designated in respect of that country under the Hague Convention or any other relevant civil procedure convention, is evidence of the facts stated in the certificate. 5. A document purporting to be an official certificate under paragraph 4 is to be treated as such a certificate, unless it is proved not to be. Service of claim form on a state where court permits service out of jurisdiction 7.11(1). This rule applies where a claimant wishes to serve a claim form on a state. 2. Where that state has agreed to a method of service other than a method permitted by this part, the claim may be served either by the method agreed or in accordance with the other rules in this part. 3. The claimant must file at the court office a request for service to be arranged by the minister with responsibility for foreign affairs, b. a copy of the claim form, and c. any translation required by virtue of Rule 7.12. 4. The court office must send documents filed under this rule to the permanent secretary of the ministry with responsibility for foreign affairs with a request that the minister arrange for the claim form to be served. 5. An official certificate by the minister with responsibility for foreign affairs stating that a claim form has been duly served on a specified date, in accordance with a request made under this rule, is evidence of that fact. 6. A document purporting to be such a certificate is to be treated as such a certificate, unless it is proved not to be. Translation of Claim Form 7.12(1), except where paragraph 4 or 5 applies. Every copy of the claim form filed under Rule 7.10 or Rule 7.11 must be accompanied by a translation of the claim form. 2016 Supreme Court of Judicature of Trinidad and Tobago. 44. Consolidated Civil Proceedings Rules 2016. 2. The translation must be a. in the official language of the country in which it is to be served, or b. if there is more than one official language of that country, in any official language which is appropriate to the place in the country where the claim form is to be served. 3. Every translation filed under this rule must be certified by the person making it to be a correct translation, and the certificate must state a. the name of the person making the translation, b. his address, and c. his qualifications for making a translation. 4. The claimant is not required to file a translation of a claim form filed under Rule 7.9, Service through Judicial Authorities, Foreign Governments, etc., where the claim form is to be served a. in a country of which English is an official language, or b. by a consular authority of Trinidad and Tobago on a subject of Trinidad and Tobago, unless a relevant civil procedure convention expressly requires a translation. 5. The claimant is not required to file a translation of a claim form filed under Rule 7.11, Service on a State, where English is an official language of the state where the claim form is to be served. Undertaking to be responsible for expenses of minister with responsibility for foreign affairs 7.13.1. Every request for service filed under Rule 7.9, service through foreign governments, judicial authorities, etc., or Rule 7.11, service on a state, must contain an undertaking by the person making the request, a. to be responsible for all expenses incurred by the minister with responsibility for foreign affairs, and b. on being informed of the amount of those expenses, to pay that amount to the finance officer of the ministry with responsibility for foreign affairs, and 2. to produce a receipt for the payment to the court office. 2. No further step in the proceedings may be taken by the claimant until he has produced the receipt required by paragraph 1b. 2. Service of court process other than claim form 7.14. 1. An order or notice issued, made or given in any proceedings may be served out of the jurisdiction without the court's permission, if it is served in proceedings in which permission has been given to serve the claim form out of the jurisdiction. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings, Rules 2016-45. 2. The procedure by which a document specified in paragraph 1 is to be served is the same as that applicable to the service of a claim form, and accordingly Rules 7.8 to 7.13 apply. Meaning of Hague Convention. 7.15 For the purpose of this part, Hague Convention means the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters signed at The Hague on November 15, 1965. 2016 Supreme Court of Judicature of Trinidad and Tobago. 46. Consolidated Civil Proceedings Rules 2016. Cases. 2008 High Court. NH International, Caribbean, Limited v. Clico Investment Bank Limited and another CV 2006-001205, December 8, 2008, Rule 7.3, 2c. Rule 7.3, 7, Claim Form, Proper Case for Service out of Jurisdiction, also under Part 9. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-47. Part 8 How to Start Proceedings. Contents of this part: the claimant. How to start proceedings. Rule 8.1 Statement of case to be issued and served with claim form. Rule 8.2 Where to start proceedings. Rule 8.3 Right to make a claim which includes two or more claims. Rule 8.4 What must be included in claim form. Rule 8.5 Claimant's duty to set out his case. Rule 8.6 Certificate of value, small claims. Rule 8.7 Certificate as to truth. Rule 8.8 Additional matters which must be included on claim form or statement of case. Rule 8.9 Special requirements applying to claims for personal injuries. Rule 8.10 Relator claims. Rule 8.11 Service of a claim form. Rule 8.12 Time within which a claim form may be served. Rule 8.13 Extension of time for serving claim form. Rule 8.14 Defense form, etc. must be served with claim form. Rule 8.15 The claimant. How to start proceedings. 8.1.1 Proceedings are started by filing in the court office the original and one copy, for sealing, of a claim form, and b. the claimant's statement of case. 2. A claim is issued on the date entered on the claim form by the court office. 3. A claim form must be in Form 1 or 2, with or without variations. 4. Form 2, fixed date claim, must be used if a. in proceedings for possession of premises which are occupied in whole or in part for residential purposes, or 2. subject to any statutory restrictions on the claimant's right to possession, b. in claims arising out of hire purchase or credit sale agreements. 2016 Supreme Court of Judicature of Trinidad and Tobago. 48 Consolidated Civil Proceedings Rules 2016. C. Whenever its use is required by a rule or practice direction, and d. whereby any enactment proceedings are to be commenced by originating summons or motion. 5. A person must make an application under Part 11 if he seeks a remedy from the court A. before proceedings have been started, or B. in relation to proceedings which are taking place, or will take place, in another jurisdiction. Statement of case to be issued and served with Claim Form 8.2. 1. A claim form may be issued and served without the claimant's statement of case only where a. any of these rules requires an affidavit to be filed in support of a claim. B. The claimant has included in the claim form all the information required by Rules 8.6, 8.7, and 8.8, or C. The court gives permission. 2. The court may only give permission if it is satisfied that a. the claim must be issued as a matter of urgency and that it is not practicable for the claimant to prepare a statement of case, or b. a relevant limitation period is about to expire and the claimant has only obtained legal advice within the 7 days prior to the date that he wishes to file his claim, provided that where the claimant at the time of the application for permission has been granted legal aid by the legal aid and advisory authority, the court may grant permission. Notwithstanding that the claimant is unable to satisfy the court that he has only obtained legal advice within the 7 days prior to the date that he wishes to file his claim. 3. An application for permission may be made without notice but must be supported by evidence. 4. Any order giving permission for the claim form to be served without a statement of case must state a date by which the statement of case must be served. 5. Such date must in no case be more than 2 months from the date of service of the claim form. 6. A copy of the order must be served with the claim form. Where to start proceedings. 8.3. 1. The general rule is that a claim may be started in any court office of the High Court. 2. However, Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings, Rules 2016-49. Any proceedings relating to land in Tobago or based on a cause of action which arose in Tobago must be started in the court office at Tobago, and b. Practice directions may require that claims of a specified type must be issued in a particular court office. Right to make a claim which includes 2 or more claims. 8.4. A claimant may make a claim which includes all, or any, other claims which can be conveniently disposed of in the same proceedings. What must be included in Claim Form 8.5? 1. The claim form must a. include a short description of the claim, and b. specify any remedy that the claimant is seeking, though this does not limit any power of the court to grant any other remedy to which he may be entitled. 2. If the claimant is seeking exemplary damages, he must say so expressly on the claim form. 3. If the claimant is seeking interest, he must a. say so expressly on the claim form, and b. include details of I. the basis of entitlement, 2. the rate, 3. the period for which it is claimed, 4. where the claim is for a specified amount of money, the total amount of interest claimed to the date of the claim, and v. the daily rate at which interest will accrue after the date of the claim, on the claim form or in his statement of case. 4. If the claimant is claiming in a representative capacity under Part 21, he must state what that capacity is. 5. If the defendant is sued in a representative capacity under Part 21, the claimant must state what that capacity is. Claimant's duty to set out his case. 8.6. 1. The claimant must include on the claim form or in his statement of case a short statement of all the facts on which he relies. 2. The claim form or the statement of case must identify or annex a copy of any document which the claimant considers necessary to his case. 2016 Supreme Court of Judicature of Trinidad and Tobago. 50 Consolidated Civil Proceedings Rules 2016. Certificate of Value, Small Claims. 8.7. If the amount of any damages claimed is not specified, the claim must include a certificate by the claimant or his attorney at law that the damages claimed exceed or are likely to exceed $15,000 or the basis on which it is said that the High Court has jurisdiction. Certificate as to truth. 8.8. 1. The claimant must certify on the claim form or his statement of case that he believes that the contents are true and that he is entitled to the remedy claimed. 2. If it is impractical for the claimant to give the certificate required by paragraph 1, it may be given by his attorney at law. 3. If the certificate is given by the attorney at law, he must also certify a. the reasons why it is impractical for the claimant to give the certificate, and b. that the certificate is given on the claimant's instructions. Additional matters which must be included on claim form or statement of case 8.9. 1. Where the claim is for possession of land, the claimant must state a. whether his right to possession is subject to any, and if so what, statutory restrictions, and b. whether any part of the premises is occupied for residential purposes. 2. Where the claim form is issued by an attorney at law, it must be a. signed by the attorney at law, b. give his name and business address and facsimile transmission number, if any, and c. if that address is not within 3 miles of the court office where the claim form is issued, give an address for service within that area, and d. if the claim form is issued by an agent, it must be signed by the agent and give his and his principal's name, address, and address for service. 3. Where the claim form is signed by the claimant personally, or in the case of a body corporate, by an officer of that body corporate, it must give the claimant's address, and if that address is not within 3 miles of the court office. Where the claim form is issued, an address for service within that area. Special requirements applying to claims for personal injuries 8.10. 1. This rule sets out additional requirements with which a claimant in a claim for personal injuries must comply. 2. The claim form or the statement of case must state the claimant's date of birth or age. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-51. 3. If the claimant will be relying on the evidence of a medical practitioner, the claimant must attach to the claim form a report from a medical practitioner on the personal injuries which he alleges in his claim. 4. The claimant must include in, or attach to, his claim form or statement of case a schedule of any special damages claimed. Relator claims. 8.11 No person's name may be used in any claim as a relator unless that person has given written authority for his name to be used and the authority is filed at the court office before the claim is issued. Service of a claim form. 8.12 After a claim has been issued, the claim form and statement of case may be served on the defendant in accordance with Part 5, Service of Claim Form, or Part 7, Service out of the jurisdiction. Time within which a claim form may be served. 8.13. 1. The general rule is that a claim form may only be served within 4 months after the date when the claim was issued. 2. The period of service is 6 months where the claim form is to be served out of the jurisdiction. 3. The period of service of an admiralty claim form in rem is 12 months. 4. A claim, including a counterclaim, ancillary claim, and other similar claims, shall be automatically struck out if a claim form is not served within 6 months of the time fixed by paragraph 1, or extended for service. 5. Where a claim form is duly served and a defendant either does not enter an appearance or file a defense and the claimant who can, does not apply for judgment pursuant to Part 12 within 6 months of becoming entitled to do so, the claim, including a counterclaim, ancillary claim, and other similar claims, shall be automatically struck out. 6. The striking out of a claim under this rule shall not prevent a party from filing new proceedings in respect of the same cause or matter within the relevant period of limitation, except that where a claim is twice struck out, the claimant shall obtain the permission of the court to file new proceedings in respect of such cause or matter. Part 7 deals with service out of the jurisdiction. Part 74 deals with admiralty proceedings. Part 9 deals with appearance and notice of intention to defend. Part 10 deals with filing of a defense. Part 12 deals with default judgments. Part 18 deals with counterclaims, ancillary claims, and other similar claims. LN 126 of 2011. 2016 Supreme Court of Judicature of Trinidad and Tobago. 52 Consolidated Civil Proceedings Rules 2016. Extension of time for serving claim form 8.14. 1. the claimant may apply for an order extending the period within which the claim form may be served. 2. The general rule is that an application to extend the time for service must be made within the period for serving the claim form specified by Rule 8.13. 3. If the claimant applies for such an order after the end of the period specified by Rule 8.13, the court may make such an order only if it is satisfied that the claimant has taken all reasonable steps, I, to trace the defendant, and 2, to serve the claim, but has been unable to do so, and when the claimant has acted promptly in making the application. 4. An application for an order extending the time for service may be made without notice, but it must be supported by evidence. Defense form, etc., must be served with Claim Form 8.15. 1. When a claim form and statement of case are served on a defendant, it must be accompanied by a form for entering appearance, Form 3 or 4, b. a defense form, Form 5, c. in the case of a money claim, an application to pay by installments, Form 3a, d. the prescribed notes for defendants, Form 1a, and e. a copy of any order made under Rule 8.2 or 8.14. 2. There must be inserted on each form a. the address of the court office to which the defendant is to return the forms, b. the title of the claim, and c. the reference number of the claim. 3. Where there is a standard defense form appropriate to the particular case set out in a practice guide, the form sent to the defendant must be in a standard form of that type. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-53. Former rule. The current Rule 8.13 was brought about by the revocation and substitution of Rule 8.13 by Rule 4 of the Civil Proceedings, Amendment, Rules, 2011 Legal Notice No. 126 of 2011. As set out in the 2006 publication, Rule 8.13 read as follows. Time within which a claim form may be served. 8.13. 1. The general rule is that a claim form may only be served within 4 months after the date when the claim was issued. 2. The period for service is 6 months, where the claim form is to be served out of the jurisdiction. 3. The period for service of an admiralty claim form in rem is 12 months. Part 7 deals with service out of the jurisdiction. Part 74 deals with admiralty proceedings. 2016 Supreme Court of Judicature of Trinidad and Tobago. 54 Consolidated Civil Proceedings Rules 2016. Cases. 2015 Privy Council/Court of Appeal. Bisham Sundar Singh v. Anthony Wilson and others. Civ App No. 226 of 2015. Appeal pending. CV 2010-05022. CV 2011-00197, July 30, 2015, Rule 8.5. 3. Claim Form, Failure to Plead Interest. Andrew Samuel and others v. BG Trinidad Central Block Limited and another. Civ App Nos. S. 110, 129, 130, 131 and 132 of 2014, July 13, 2015, appeal dismissed. CV 2012-00367, April 8, 2015, Rule 8.13, Rule 8.14. Late service, claim form, statement of case, insufficient evidence, TO show service, Rule 8.14 requirements unsatisfied. First Citizens Bank Limited v. Shepboys Limited and another. Civ App No. P231 of 2011, March 10, 2015, appeal dismissed. Rule 8.6, duty TO set out case, reliance on matters in reply, also under Part 10. Medical Professionals Association of Trinidad and Tobago v. Fidel Rampersad and others. Civ App No. P337 of 2014, January 26, 2015, appeal allowed. CV 2014-01330, January 23, 2015, Part 8.2, Permission TO file claim form without statement of case, discretion, also under Parts 1 and 26. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-55. High Court. Riyadh Marketing Limited v. Eckler Chemicals Limited CV 2015-00670, December 16, 2015, Rule 8.13, Claim Form Service of Proceedings, Purpose of Service, also under Part 5. Crystal Roberts and another v. Dr. Samantha Bagan and another CV 2010-01117, November 30, 2015, Rule 8.10, Personal Injuries, Amended Reply, First Introduction of Medical Reports, striking out, also under Parts 1 and 33. Subarter Dionarine v. Jamwanti Satnarine and others CV 2014-01431, July 23, 2015, Rule 8.5, Statement of Case, Failure to plead interest, also under Part 26. Revs Mechanical Engineering Services Limited v. Attorney General of Trinidad and Tobago CV 2014-02604, April 14, 2015, Rule 8.2, Rule 8.6, Claim Form without Statement of Case, Requirements for Permission, Duty to set out case. 2014 Privy Council/Court of Appeal. Real-Time Systems Limited v. Renraw Investments Limited and others, 2014, UKPC 6, March 3, 2014, Appeal dismissed Rule 8.6, Statement of Case, Duty to set out facts relied upon, also under Parts 20, 26, and 35. First Citizens Bank Limited v. Marcia M. Thomas Civ App No P119 of 2011, October 6, 2014, Appeal allowed CV 2008-03280, May 4, 2011, Rule 8.6 Failure to include material facts. 2016 Supreme Court of Judicature of Trinidad and Tobago. 56 Consolidated Civil Proceedings Rules 2016. Dennis Gillard v. the Attorney General of Trinidad and Tobago Civ App No P192 of 2013, February 11, 2014, Appeal dismissed CV 2009-03903, July 29, 2013, Permission for Default Judgment, whether Rule 8.13 applicable, also under Parts 12 and 26. High Court. African Option and another v. Bank of Baroda, Trinidad and Tobago, Limited CV 2013-05221, October 14, 2014, Rule 8.7, Rule 8.8, Commencement of Proceedings, Certificate of Truth, whether pleadings defective, also under Part 26. Central Bank of Trinidad and Tobago and another v. Lawrence Dupree and others CV 2011-02140, June 18, 2014, Rule 8.6, Duty to set out case, reply, striking out parts, also under Part 10. 2013 Privy Council/Court of Appeal. LJ Construction Co. Ltd. v. Janice Solomon Civ App No P042 of 2013, March 18, 2013, Appeal allowed Rule 8.3, Tobago, Commencement of Proceedings, also under Part 26. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-57. 2012 Privy Council/Court of Appeal. Nature Resorts Limited v. First Citizens Bank Limited Civ App No P110 of 2012, June 4, 2012, Appeal allowed CV 2011-02339, March 29, 2012, Part 8, Rule 8.6, Claim Form and Statement of Case, Duty to set out case. High Court. Juliana Webster v. Republic Bank Limited and others CV 2011-03158, October 12, 2012, Rule 8.1, Claim Form versus Fixed Date Claim Form, Mixed Claim, striking out, Abuse of Process, also under Part 56. Fitzroy Philip v. the Attorney General of Trinidad and Tobago CV 2008-02197, July 27, 2012, Rule 8.6, Statement of Claim, Sufficiency of Claim. Export-Import Bank of Trinidad and Tobago v. Water Works Limited and others CV 2010-03594, May 1, 2012, Rule 8.6, Statement of Case, Defective Pleading, Opportunity to give further particulars, also under Parts 10 and 26. Anil Maharaj v. Rudy Rupnarine and another CV 2012-04524, April 19, 2012, Rule 8.5, Rule 8.6, Pleadings, Failure to plead interest, Annexation of supporting documents. Elias Alexander v. the Attorney General of Trinidad and Tobago CV 2010-2501, February 16, 2012, Rule 8.2, NO Statement of Case filed with claim form, whether claim should proceed, also under Part 26. 2016 Supreme Court of Judicature of Trinidad and Tobago. 58 Consolidated Civil Proceedings Rules 2016. ABC Trinidad Customs Brokers Limited v. Zando Distributors Limited CV 2011-00411, February 6, 2012, Part 8, Statement of Case, NO Supporting Documentation. Norma Tang v. Wendell Mac Bain and others CV 2011-02471, January 5, 2012, Rule 8.14, Rule 8.14, 3, Service of Claim Form, Extension of Time, Late Filing, Promptitude. 2011 Privy Council/Court of Appeal. Antonia Webster v. the Attorney General of Trinidad and Tobago, 2011, UKPC 22, July 18, 2011, Appeal dismissed Rule 8.1, Claim in Tort, Claim of Constitutional Breach, Mixed Claim, Fixed Date Claim Form, also under Parts 26 and 56. Russell Seaton v. the Attorney General of Trinidad and Tobago Civ App No P083 of 2011, May 3, 2011, Appeal dismissed CV 2009-03667, May 23, 2011, Rule 8.10, Statement of Case, Personal Injuries, Failure to comply, Failure to identify or annex medical documents. High Court. Samantha F. Hossain v. Central Equipment Rentals and others CV 2009-00301, June 17, 2011, Rule 8.5, Rule 8.6 Failure to particularize, Failure to plead interest. Supreme Court of Judicature of Trinidad and Tobago 2016. Consolidated Civil Proceedings Rules 2016-59. 2010 Privy Council/Court of Appeal. Charmaine Bernard v. Ramesh Sibalak, 2010, UKPC 15, July 21, 2010, Appeal dismissed Rule 8.6, Duty of Claimant to set out short statement of all facts relied on, also under Part 1. High Court. Beverly and Mativier v. the Attorney General of Trinidad and Tobago and others CV 2007-00387, February 10, 2010, Rule 8.6, Statement of Case, Duty to include material facts, NO Cause of Action. Ivan Neptune v. the Attorney General of Trinidad and Tobago CV 2008-03386, January 25, 2010, Rule 8.1, Mixed Claim, Mode of Commencement, Constitutional Relief, Fixed Date Claim Form, also under Part 56. 2009 Privy Council/Court of Appeal. Baidwadi Ramnarine v. Aziz Muhammad and others Civ App No S241 of 2009, December 7, 2009, Appeal allowed CV 2009-00202, July 12, 2011, Part 8, Witness Statement, Annexure, Hearsay, Departure from Pleadings. 2016 Supreme Court of Judicature of Trinidad and Tobago. 60 Consolidated Civil Proceedings Rules 2016. 2007 High Court. Gerard Mahadio v. Jessel R. Ramsinder CV 2007-01218, November 30, 2007, Service of Claim Form, Extension of Time, Alternative Addresses, also under Part 5. Dana Daniel and another v. Ghani Muhammad CV 2006-03578, May 23, 2007, Rule 8.14, Rule 8.14, 3. Consideration of factors, reasonable steps to serve claim form, promptitude. Joan Jacob v. Housing Development Corporation CV 2006-01401, March 22, 2007, Rule 8.6, Statement of Case, Non-disclosure of necessary documents. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-61. Part 9 Appearance and Notice of Intention to defend. Contents of this part. Scope of this part. Rule 9.1 Entering appearance and consequence of not doing so. Rule 9.2 The period for entering an appearance. Rule 9.3 Notice to claimant of entry of appearance. Rule 9.4 Contents of appearance. Rule 9.5 Right to dispute the jurisdiction of court, not taken away by appearance. Rule 9.6 Procedure for disputing court's jurisdiction. Rule 9.7 Scope of this part. 9.1 1. This part deals with the procedure to be adopted by a defendant who wishes to contest proceedings and avoid a default judgment being entered against him. 2. He does so by entering an appearance containing a notice of intention to defend. Entering appearance in consequence of not doing so. 9.2 1. If the defendant wishes a. to dispute the claim, or b. to dispute the court's jurisdiction, he must enter an appearance giving notice of intention to defend. 2. However, he need not enter an appearance if he files a defense within the period specified in Rule 9.3. 3. If he fails to do so, judgment may be entered if Part 12 allows it. 4. An appearance may be entered at any court office even though the claim was not issued from that court office. 5. However, that does not mean that the claim is to be transferred to the court office at which the appearance is entered. 6. In civil proceedings against the state begun in the court office of San Fernando, the Attorney General may enter an appearance in the court office at Port of Spain, and the proceedings shall continue in that court office until further order. Part 58 defines civil proceedings against the state. 2016 Supreme Court of Judicature of Trinidad and Tobago. 62 Consolidated Civil Proceedings Rules 2016. The period for entering an appearance. 9.3 1. The general rule is that the period for entering an appearance is the period of 8 days after the date of service of the claim form. 2. Where permission has been given under Rule 8.2 for a claim form to be served without a statement of case, the period for entering an appearance is the period of 8 days after the service of the statement of case. 3. However, a defendant may enter an appearance at any time before a default judgment is entered. 4. The general rule does not apply where a. the claim form is served outside the jurisdiction in accordance with Part 7, or b. the claim form is served on an agent of an overseas principal under Rule 5.15. Rules 7.7 and 5.15 deal with the time for entering an appearance in those cases. Notice to claimant of entry of appearance. 9.4 1. When the defendant enters an appearance, the court office must notify the claimant in writing that it has been entered. 2. A copy of the appearance and any statement of fact filed with it must be annexed to the notice. Contents of appearance. 9.5 1. An appearance must state the date on which the defendant received the claim form. 2. A defendant may state in an appearance that he admits all or part of the claim. 3. A defendant who admits part of the claim must state the amount that he admits. 4. Where a defendant admits all or part of the claim, he may file with his appearance a. his proposals for payment of any sums for which he admits liability, and b. details of his financial circumstances. Part 14 deals with the way in which such proposals are decided. 5. If a defendant admits part of the claim, he must also file a defense as to that part which he disputes within the time for filing a defense. Rule 10.3 sets out the time for filing a defense. 6. An appearance must be signed by the defendant or his attorney at law. 7. The defendant must include in an appearance an address to which documents may be sent. LN 126 of 2011. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-63. 8. That address must be within 3 miles of the court office at which the claim was issued. Right to dispute jurisdiction of court not taken away by appearance. 9.6 A defendant who enters an appearance does not by doing so lose any right that he may have to dispute the court's jurisdiction. Procedure for disputing court's jurisdiction. 9.7 1. A defendant who wishes a. to dispute the court's jurisdiction to try the claim, or b. to argue that the court should not exercise its jurisdiction, may apply to the court for an order declaring that it has no such jurisdiction or should not exercise any jurisdiction which it may have. 2. A defendant who wishes to make such an application must first enter an appearance. 3. An application under this rule must be made within the period for filing a defense. Rule 10.3 sets out the period for filing a defense. 4. An application under this rule must be supported by evidence. 5. If the defendant a. enters an appearance, and b. does not make such an application within the period for filing a defense, he is treated as having accepted that the court has jurisdiction to try the claim. 6. An order containing a declaration that the court has no jurisdiction or will not exercise its jurisdiction may also make further provision including a. striking out any statement of case, b. setting aside service of the claim form and statement of case, and c. discharging any order made before the claim was commenced or the claim form served. 7. If on application under this rule the court does not make a declaration, it a. must make an order as to the period for filing a defense, and b. may treat the hearing of the application as a case management conference. Part 26 sets out powers which the court may exercise on a case management conference. 2016 Supreme Court of Judicature of Trinidad and Tobago. 64 Consolidated Civil Proceedings Rules 2016. 8. Where a defendant makes an application under this rule, the period for filing a defense is extended until the time specified by the court under paragraph 7a. and such period may only be extended by an order of the court. Former rule. The current Rule 9.4 was brought about by the deletion and substitution of Subrule 2 by Rule 5 of the Civil Proceedings, Amendment, Rules, 2011 Legal Notice No. 126 of 2011. As set out in the 2006 publication, Subrule 2, read as follows. 2. A copy of the appearance must be annexed to the notice. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-65. Cases. 2015 Privy Council/Court of Appeal. David Walcott v. Eastern Credit Union and another Civ App No. P121 of 2012, April 29, 2015, appeal dismissed CV 2011-02378, April 26, 2012, Rule 9.7 Jurisdiction, claim struck out. 2014 Privy Council/Court of Appeal. The National Gas Company of Trinidad and Tobago v. Gordon Winter Company Limited Civ App No. P234 of 2013, June 25, 2014, appeal dismissed Rule 9.7, stay of proceedings, jurisdiction, inherent jurisdiction not ousted by CPR. L.J. Williams Limited v. Zim Integrated Shipping Services Limited and another Civ App No. P059 of 2014, June 4, 2014, appeal dismissed Rule 9.7, stay of proceedings, jurisdiction. High Court. KGC Company Limited v. The owners and or parties interested in the motor vessel Bywater Liberty CV 2013-01209, March 18, 2014, Admiralty Proceedings, Claim and Rem. A time for entering appearance, Part 9 applies, also under Parts 10 and 74. 2016 Supreme Court of Judicature of Trinidad and Tobago. 66 Consolidated Civil Proceedings Rules 2016. 2013 High Court. Stanley Holder v. the Attorney General of Trinidad and Tobago CV 2011-04480, July 26, 2013, Rule 9.2, Rule 9.3 The entry of defense, requirement for appearance, also under Parts 27 and 58. 2011 Privy Council/Court of Appeal. Sarah Young and others v. Lena Pegus and another Civ App No. P271 of 2010, February 14, 2011, appeal dismissed CV 2008-00876, December 17, 2010, jurisdiction, failure to comply with Rule 9.7, also under Parts 3 and 5. High Court. West Indies Players Association v. West Indies Cricket Board Inc. CV 2011-03130, November 9, 2011, Rule 9.7, 3, Rule 9.7, 4, jurisdiction, failure to comply with Rule 9.7. 2008 High Court. NH International, Caribbean, Limited v. Clico Investment Bank Limited and another CV 2006-01205, December 8, 2008, Rule 9.7 Jurisdiction, Forum Convenience, Joinder of Party, Service out of the Jurisdiction, also under Part 7. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-67. Part 10 Defense. Contents of this part. Scope of this part. Rule 10.1 The defendant filing defense and consequences of not doing so. Rule 10.2 The period for filing defense. Rule 10.3 Service of copy of defense. Rule 10.4 Defendant's duty to set out his case. Rule 10.5 Consequences of not setting out defense. Rule 10.6 Additional matters which must be included in defense. Rule 10.7 Special requirements applying to claims for personal injuries. Rule 10.8 Defense of tender. Rule 10.9 Reply to defense. Rule 10.10 Scope of this part. 10.1 The rules in this part set out the procedure for disputing the whole or part of a claim. Part 18 deals with the procedure for making a counterclaim. The defendant, a filing defense and the consequences of not doing so. 10.2 1. A defendant who wishes to defend all or part of a claim must file a defense. 2. Where a defendant admits liability, but wishes to be heard on the issue of quantum, he need not file a defense but shall indicate on his appearance form referred to in Rule 9.4, 2, that he wishes to a. Cross-examine any witness called on behalf of the claimant, b. Make submissions to the court, or c. Call any evidence, in which case he shall file with the appearance form a statement of facts upon which he intends to rely. 3. If a defendant fails to file a defense within the period for filing a defense, judgment for failure to defend may be entered if Part 12 allows it. Part 14 deals with the procedure to admit all or part of the claim. LN 126 of 2011. 2016 Supreme Court of Judicature of Trinidad and Tobago. 68 Consolidated Civil Proceedings Rules 2016. The period for filing defense. 10.3 1. The general rule is that the period for filing a defense is the period of 28 days after the date of service of the claim form and statement of case. 2. However, a. Where permission has been given under Rule 8.2 for a claim form to be served without a statement of case, or b. Where a statement of case is amended pursuant to Rule 20.1, the period for filing a defense is the period of 28 days after the service of the statement of case or the amended statement of case, as the case may be. 3. In proceedings against the state, the period for filing a defense is the period of 42 days after the date of service of the claim form and statement of case. 4. Where the defendant within the period set out in paragraph 1, 2, or 3 makes an application under Section 7 of the Arbitration Act, Chap. 501, to stay the claim, the period for filing a defense is extended to 14 days after the determination of that application. 5. A defendant may apply for an order extending the time for filing a defense. 6. The parties may agree to extend the period for filing a defense specified in paragraph 1, 2, or 3, up to a maximum of 3 months after the date of service of the claim form, or statement of case if served after the claim form. 7. Only one agreement to extend the time for filing a defense may be made. 8. The defendant must file details of such an agreement. 9. Any further extensions may only be made by court order. 10. The general rule is subject to Rule 9.7. Service of copy of defense 10.4. When the defendant files a defense, he must also serve a copy on all other parties. Defendant's duty to set out his case 10.5. 1. The defendant must include in his defense a statement of all the facts on which he relies to dispute the claim against him. 2. Such statement must be as short as practicable. 3. In his defense the defendant must say, a. which, if any, allegations in the claim form or statement of case he admits, b. which, if any, he denies, and LN 301 of 2012. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-69. C. Which, if any, he neither admits nor denies, because he does not know whether they are true, but which he wishes the claimant to prove. 4. Where the defendant denies any of the allegations in the claim form or statement of case. A. He must state his reasons for doing so, and b. If he intends to prove a different version of events from that given by the claimant, he must state his own version. 5. If, in relation to any allegation in the claim form or statement of case, the defendant does not a. admit or deny it, or b. put forward a different version of events, he must state each of his reasons for resisting the allegation. 6. The defendant must identify in or annex to the defense any document which he considers to be necessary to his defense. Consequences of not setting out defense 10.6. 1. The defendant may not rely on any allegation which he did not mention in his defense, but which he should have mentioned there, unless the court gives him permission to do so. 2. The court may give the defendant such permission at a case management conference. 3. The court may not give the defendant such permission after a case management conference unless the defendant can satisfy the court that there has been a significant change in circumstances which became known after the date of the case management conference. Additional matters which must be included in defense. 10.7. 1. Where the defense is filed by an attorney at law, it must a. be signed by the attorney at law, b. give his name and business address and facsimile transmission number, if any. C. If that address is not within 3 miles of the court office where the claim form was issued, give an address for service within that distance, and d. If the defense is filed by an agent, be signed by the agent and give his name and address for service. 2. Where the defense is filed by the defendant personally, or in the case of a body corporate by an officer of that body corporate, it must give an address at which documents may be served, unless he has filed an appearance which includes such an address. 2016 Supreme Court of Judicature of Trinidad and Tobago. 70 Consolidated Civil Proceedings Rules 2016. 3. That address must be within 3 miles of the court office where the claim was issued. 4. The defendant must certify on the defense that he believes that its contents are true. 5. If it is impractical for the defendant to give the certificate required by paragraph 4, it may be given by his attorney at law. 6. If the certificate is given by the attorney at law, he must also certify the reasons why it is impractical for the defendant to give the certificate and that the certificate is given on the defendant's instructions. 7. If the defendant is defending in a representative capacity, he must say, a. what that capacity is, and b. whom he is representing. Part 21 deals with representative parties. Special requirements applying to claims for personal injuries 10.8. 1. This rule sets out additional requirements with which a defendant to a claim for personal injuries must comply. 2. Where the claimant has attached to his claim form a report from a medical practitioner on the personal injuries which he is alleged to have suffered, the defendant must state in his defense, a. whether he agrees the medical report, and b. where he disputes any part of the medical report, give his reasons for doing so. 3. Where the defendant intends to rely on a report from a medical practitioner to dispute any part of the claimant's claim for personal injuries and the defendant has such a report in his possession, the defendant must attach that report to the defense. Defense of tender 10.9 The defense of tender shall not be available unless the defendant pays into court the amount alleged to have been tendered within the period for filing a defense. Rule 10.3 states the period for filing a defense. Reply to Defense 10.10 1. A claimant may not file or serve a reply to a defense without a. The permission of the court, or b. If it is to be filed before a case management conference, the consent of the defendant. 2. The court may only give permission at a case management conference. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules, 2016-71. Former Rule 1. The current Rule 10.2 was brought about by the deletion and substitution of Subrule 2 by Rule 6 of the Civil Proceedings Amendment Rules, 2011 Legal Notice No. 126 of 2011. As set out in the 2006 publication, Subrule 2 read as follows. 2. In particular, if a defendant admits liability but wishes to be heard on the issue of quantum, he must file and serve a defense dealing with that issue. 2. The current Rule 10.3 was brought about by the deletion and substitution of Subrule 2 by Rule 5 of the Civil Proceedings Amendment Rules, 2012 Legal Notice No. 301 of 2012. As set out in the 2006 publication, Subrule 2 read as follows. 2. However, where permission has been given under Rule 8.2 for a claim form to be served without a statement of case, the period for filing a defense is the period of 28 days after the service of the statement of case. 2016 Supreme Court of Judicature of Trinidad and Tobago. 72 Consolidated Civil Proceedings Rules 2016. Cases. 2015 Privy